The order that has come to the surface yesterday regarding 23rd February proceedings shows the extraordinary time we find ourselves in the Supreme Court, where over time, over the past few years, especially through the Qazi Faiz Isa reference, matters have come to a head and divides have become so great that this court is now seething with differences of opinion that should have originally and consistently been part of its larger benches, which were hearing issues of greater constitutional importance than any normal issue before the court, or specifically issues of political importance. Also, this question about four judges recusing themselves is in itself troubling to me, because whilst you can say that Justice Yahya Afridi showed his mind and then left it to the Chief Justice to determine that he should continue or not, meaning that that was a half recusal. And perhaps it was appropriate because he said that he was dismissing the petitions, although I don't understand why he would say that at this stage. But nowhere from Justice Manilla's order do I see him saying he is not interested in being part of the bench. Yes, he stressed strenuously on the Chief Justice being propriety, being that the Chief Justice constitutes a full court, but he didn't say he didn't want to be a part of this. So I don't understand how that recusal came about, although the order of the court does state that there has been a conversation in the antechamber of the court, so perhaps something was said and done there. And the recusals of Justice Naqvi, Mazahir Naqvi, and Justice Ijazul Ehsan are also not on the record. So we don't know what prompted them to recuse themselves. Was it the comments of the other members of the bench? Was it the Chief Justice himself? Because he did say that it was magnanimous of them. But, that doesn't really cut it. We'd like to know what, I'd like to know, at least as an officer of the court, what led to this bench being formed in the way that it was formed, and what led to its dissolution. And it is unprecedented, and rightly so, because these things come about after matters come to a head, and these matters have been simmering for a number of years now, where benches have been fixed by the Chief Justices, not just the incumbent Chief Justice, but also his worthy predecessors, in ways that have led to questions being asked of them. And Justice Shah made clear that how could you it becomes even more nuanced, was his term, that on the one hand you're removing and depriving the bench from the experience of the likes of Justice Isa and Justice Tariq Masood, but on the other you are willing to take on to the bench someone who really should not be on this bench or any bench with regards which has anything to do with politics until the allegations surrounding that individual, meaning Justice Naqvi, are settled. And the way the Chief Justice has approached the allegations against Justice Naqvi are so markedly different from the way he approached the allegations against Justice Isa, even though the weight of the allegations are worlds apart. Justice Isa had a competent story to tell, and he was yet harangued by a hybrid regime and its establishment and its bureaucracy on the premise of some technical issues. Whilst over here, the allegations are so severe and there are no technical things to hide behind other than the fact that the audio is illicit, has been gathered illegally. And yet, in Justice Isa's case, we were told that a judge must hold himself to the highest of standards. We were told, we were quoted from the Quran, we were told hadith, and it was all writ large in orders that, what do you have to hide? If you have nothing to hide, why not explain yourself? And yet with Justice Naqvi, there is complete radio silence. Similarly, the angst shown by Justice Yahya Afridi must be given space. The angst shown by Justice Mando Khail must be given space. It can't just come to the point of additional notes. There must be a consensus upon who is going to hear these kind of proceedings. The Chief Justice cannot, just by virtue of being the master of the roster, which is an administrative power, cannot then use this as an absolute way of commandeering a bench which other judges are saying lacks seniority, lacks the abundance of expertise available to the court. These are now not just the statements of one senior judge. This is now a court-wide position, as can be seen from all the additional notes, and especially with the statement given by Justice Mansoor Ali Shah, where firstly he shows his contempt towards the inclusion of Justice Naqvi in this bench and how it was inappropriate. He makes clear that the suo motu arose from an eagerness that was unwarranted, that was exhibited by Justice Ehsan and Justice Naqvi in the first place, in a case that didn't concern the Election Commission or a date for elections. That was an appeal from a tribunal about the removal of a CCPO. That CCPO himself has become the reason why certain audio leaks have surfaced, which show perhaps a nexus at least between a lawyer for the policeman and someone who is supposed to be close to the judge. Allegedly, the audio leaks have not been disregarded by the judge in private hearing of a Supreme Court meeting. He has instead said that they date from a different time, meaning that he has accepted the fact that he was talking to a political figure with such frankness. All of these are extraordinary things that have surfaced in all of these orders. And the demand for a full court is the most consistent demand that is coming across from all of these positions. It is extraordinary that a judge, a junior judge, and a junior most judge of the Supreme Court in Justice Athar Minilla has had to resort to having to state in his order that the order that was issued by the court as an order of the court was not consistent with what was dictated in court and the proceedings of court. Now, this is a very strong statement to give, and for Justice Manila or someone in his position, it must have come about due to a great necessity, where he felt that his position was being disregarded and undermined, which was the case in the main order, frankly, because that's why he went ahead and penned his own order and made explicit the questions he had, that he was told would be made part of the proceedings and would be made part of the order.